I'd like to welcome you to the IACP's Public Recording of Police webinar program. My name is Lisa Judge, and I'm a legal advisor for the Tucson Police Department in Tucson, Arizona. I've been involved with the IACP's Legal Officers section for over 2 decades. I'm a past chair of the Legal Officers section, and I'm currently a contributing member of the IACP's Law Enforcement Policy Center. This training program is the product of work performed by the International Association of Chiefs of Police with funding from the U.S. Department of Justice, Office of Community-Oriented Policing Services, otherwise known to most of us as COPS. In addition to this webinar, the project has developed materials for law enforcement agencies to use in training their employees on the public's right to record, to include classroom curriculum and a roll call video. If you'd like more information about any of these training programs, you can visit the IACP's website at www.theiacp.org/prop. So why should the issue of officers being recorded by members of the public matter to today's police officers? Well, the immediate and easy answer is that everyone today has a camera that has recording capabilities, and anything they record can be immediately posted up on the internet within minutes or possibly even seconds. And I'm going to use the acronym PROP to describe this phenomenon in the rest of the training. So I think it's important to consider that, not so long ago, it was pretty easy for officers to identify a member of the press and or someone who was taking photographs or video of a person or scene. The camera hanging around somebody's neck or a video propped on someone's shoulder was a dead giveaway, alerting officers to the possibility that they and whatever they were doing might show up on TV or in the news. Now anyone and everyone is a potential citizen journalist with the ability to easily record an event and immediately post it on social media. I think it's definitely human nature to shy away from uninvited scrutiny or criticism, especially when it's being done using a video recording that can really live on for eternity on the internet, subjecting an officer or really anybody to unending humiliation. The prevalence of social media outlets like YouTube make it possible for such a video to be shared around the world almost instantaneously. And as we know, once it's out there, especially if it's in any way sensational, and that's in either a good or bad sense, it can go viral and have far-reaching and long-lasting consequences for officers, their agencies, and the profession. I think most of us would realize that this is not the 15 minutes of fame that anyone is hoping for. Some outlets, to include one developed by the ACLU, encourage and even facilitate the posting of these kinds of videos involving police misconduct. But with all of that said, I think we just have to face the reality that recording devices are everywhere, and more than ever, officers should anticipate that their actions are being recorded anytime they're in a public place. This phenomenon of increased recording of police officers doing their jobs ties directly into the increased focus on police legitimacy and accountability. These two bullet points are inextricably linked. The recording and dissemination of the beating of Rodney King back in March of 1991 forever changed the landscape concerning the role of video taken by the public in holding police accountable for their actions. As technology advances and cameras are more and more present, this type of scrutiny is unavoidable and ever increasing. In fact, in this day and age, officers should always presume they're being recorded, even if they're not aware of it. And if it happens that misconduct is recorded, it should also be assumed that there's probably going to be a call for accountability not far behind. And this really isn't a negative thing, but it's really an acknowledgement of what the reality is in this age of readily available technology. Recording of everyone, not just police officers, is a simple fact of life and a trend that shows no signs of fading. But at the end of the day, we have to remember that officers have sworn an oath to defend and uphold the Constitution, and they have a duty to protect the constitutional rights of the public. As we know, one of the most heavily protected of these rights is the First Amendment's guarantee of free speech and the ability to use that speech to hold government accountable. However, it's important to acknowledge the natural human tendency to dislike being recorded. Nobody likes having their actions captured on film, especially if they're not acting, they're not having their best moment. This natural discomfort is definitely in tension with the obligation that officers have to defend the constitutional rights of individuals. An officer's own comfort level sometimes must necessarily take a back seat to their duty to uphold the Constitution. So officers have to try to seek a balance between their own concerns and legitimate concerns for safety and the need to do their job with that obligation that they have to protect First Amendment rights of individuals. So officers should be aware of when they're being recorded and how they should react and have a plan, but we're going to talk a little bit more about that later. So critical to reaching that kind of balance is having a thorough understanding of the scope of rights associated with people who want to record public officials and the corresponding responsibilities of both officers and individuals in the exercise of those rights. So let's talk about what the constitutional rights of the public and the press are to record police activities. First of all, it's well-established law that individuals have a First Amendment right to record law enforcement officers who are conducting public business. The full and free ability to discuss public affairs and the conduct of government officials is a fundamental right of the public. It's also established that people have the same rights to record officers who are engaged in their duties as members of the press. So there's really no meaningful distinction between an actual formal member of the press with press credentials and a citizen journalist who's just standing out on the street with their cell phone camera who wants to record police activities. And that means that officers should treat both members of the press and citizen journalists in the same regard. The Supreme Court has also held that the First Amendment protects the right to collect and record publicly available information and to publish that information in any medium that the person chooses. So I think going along with this is the notion that this really protects people from having their videos or phones seized or destroyed, since this is related to the notion that officers cannot seek to seize or destroy recordings just to prevent their dissemination. But again, we're going to talk a little bit more about that later on in the program. So as with any right, there are limitations on the exercise of constitutional rights. First Amendment rights are the same. They're not without some limitation. Those limitations, however, are largely related to striking a balance between the individual's ability to exercise those rights and the government's need to efficiently and effectively carry out the business of the people. While a member of the public has a right to record police officers in the course of their duties, officers also have a job to do, and they've got an obligation to do it in a safe and effective manner. So what are the restrictions that we can place on folks? Well, first, individuals have to be recording in a place where they have a legal right to be present. Most often we're talking about public spaces, so places like sidewalks, streets, parks, beaches, public property and public buildings like libraries, and government buildings and other places that are generally open and available to the public. So then there's kind of a different public space that's privately owned but still open to members of the public, like shopping malls or movie theaters. They're generally considered public, but they may be subject to restrictions that can be placed by property owners or managers if they decide that a person is worthy of removal. For example, there may be a person handing out leaflets or otherwise exercising a First Amendment right in front of a local grocery store. Now, they may have received prior permission from the store manager, or they just might be out there tacitly allowed to engage in this activity because they're behaving peacefully and the store manager doesn't mind. However, if the store manager decides to ask that person to leave, they can do that as a private citizen and limit that person's ability to conduct speech activity on their private property. That's a little bit different than public property. And it's important to note in this distinction that the fact that property is owned by the government doesn't make it private property. Government-owned property is public property. Now we get to a situation where you're dealing with a private residence which isn't open and available to members of the public generally. So if somebody wants to use private property, like a front yard of someone's home, to make a videotape, that's generally going to require prior permission of the homeowner or tenant if an individual wants to enter onto it and use it to engage in First Amendment activity. I'd also like to add a little bit of a word of warning about the kind of quasi-public property that's privately owned, the shopping malls and things like that. If there's a person exercising First Amendment rights by recording police on that type of property, prior to asking that person to leave, officers should involve the property owner or manager and make sure that that's what they want to have happen to the person. Officers can't presume that they can kick somebody off of that semi-public property without the involvement of the property manager or owner. So anytime the government seeks to limit or manage the exercise of First Amendment rights, those restrictions are generally governed by what we call time, place, and manner considerations. So to kind of boil that down in a nutshell, people can't do things like place themselves or others in danger. An example of that might be standing on a busy highway. They can't enter marked scenes or perimeters that have been cordoned off by police. They can't trespass on private property, as we discussed previously. And they can't materially interfere with police activities. And this is probably one of the most important considerations for officers, but it's also probably the hardest to define. So what this really means is that individuals should not be allowed to engage in recording activity, or really any activity for that matter, that creates a significant negative impact on law enforcement operations. And that can be an example, maybe a person who's getting in the way of police officers or EMS personnel. If somebody's getting in the way like that, it's perfectly appropriate to direct them to a different spot where they're out of the way, but they can continue to exercise their First Amendment right. So if we're talking about materially interfering with police activities, I think that kind of begs the question of what really constitutes material interference. Material interference has to be based on conduct that significantly inhibits, obstructs, delays, or otherwise negatively affects police operations. Officers can do things like insist that individuals maintain a reasonable distance from the police action, and they can prohibit people from standing in areas or engaging in behavior which physically obstructs them from performing their duties. Likewise, actions that delay police or emergency responder activity, things that impede traffic or interfere with access to victims and witnesses, can be prohibited. In this kind of situation, an officer should direct the recorder to an acceptable location to continue with their filming activity, or otherwise seek an acceptable alternative that allows the officer to conduct his or her duties unimpeded. If the individual refuses to comply, at this point, it would be appropriate for officers to consider enforcement action and definitely to involve a supervisor. Another significant thing to consider is the privacy of victims or protection of sensitive police operations like hostage negotiations. Likewise, filming certain tactical operations could increase the concern for officer safety. So in these types of situations, establishing a perimeter that uses distance or even barriers as a buffer can assist in providing the necessary space so that officers can effectively carry out these kinds of sensitive duties. These types of strategies, however, should not be used simply to frustrate citizens who are trying to record ordinary police encounters, and they should be based upon real concerns for heightened needs for privacy or safety. Also, if a scene is cordoned off or is otherwise being made unavailable to someone who's trying to record, it's got to be off limits to everyone else. It's not okay to single out the person trying to exercise their right to record. Remember, if a police encounter is occurring in a public area, there's a presumption that it's fair game to be recorded. So if you've got a real need for privacy, for example, to interview a victim who might not want their worst moment posted on YouTube, or perhaps a reluctant witness or an injured person, it might be best for the officer to move that location to a private area rather than trying to control the actions of members of the public who are out there trying to exercise a right. Remember, individuals must be materially interfering before officers can intervene. It's worth mentioning that there's no expectation of privacy when you're standing out on the street during a traffic stop or a similar police action. Such interactions in public areas aren't private encounters, and they're fair game for citizen journalists seeking to document the activities of police. Another really important thing to remember is that the act of recording an officer in and of itself does not constitute interference. There's got to be some other meaningful action that the person is engaging in that's frustrating the officer's ability to do their job. If an officer is going to seek to stop a person from recording or in any other way frustrate their ability to record, they have to have an objective, articulable reason for doing so. So blocking someone from recording, obstructing them, or coercing or threatening them is not appropriate, and to the extent you're trying to stop someone from recording or moving them away, you've got to have real specific reasons for doing so. Similarly, it's also not appropriate to move somebody to an incredibly far away or unreasonable location without any sort of reason to do so, other than to frustrate their attempts to record you. Verbal criticism and derisive comments made by people who are trying to record you or others from a location that has no direct impact on police operations should not be something that officers try to respond to. In fact, officers should actively seek to avoid being baited in heated exchanges, overreactions, or unprofessional behavior. Engaging in a debate never plays out well on video, so it's probably a really good idea to show up to a scene like this with some strategies that you've developed ahead of time in your back pocket that allow you to deflect provocative or inflammatory comments, to disengage from people who are trying to be argumentative, and some strategies to de-escalate situations. It also doesn't hurt to do things like acknowledge the person's right to record, or to ask them if they'd like to speak with a supervisor and provide other opportunities of areas where they can engage in their First Amendment activity. At a minimum, officers should strive to be tactful, polite, and retain their ability to reason. This is probably your most important tool in making sure the encounter goes well and you don't wind up on YouTube in a negative light. Remember, the simple act of recording by itself does not constitute interference and doesn't justify actions to stop, block, obstruct, coerce, or otherwise threaten recording parties with citation or arrest. And it really can't be overstated that an arrest of an individual who is simply recording police activity has to be based on something else, some other violation of the law that's unrelated to the act of recording alone. Recording of police activity, in and of itself, even in states with really strict wiretapping laws, is not a sufficient basis for an arrest or issuance of a citation. So let's talk about seizing some type of recorded evidence or a recording device. Once an officer becomes aware that they're being recorded or that there's been a recording of their actions, they probably want to consider whether it might be advantageous to obtain that material if it's got some sort of evidentiary value. So if the answer to that question is yes, it would be advantageous, then careful consideration must be paid to any Fourth Amendment limitations on that seizure. Remember, individuals have a right against unlawful seizure of their recordings or devices, as well as a right against unlawful searches when officers seek to view that material. Officers should be careful to respect both aspects of those rights with regard to taking recordings or devices and viewing the contents. So, unless the individual is being arrested, officers should obtain a warrant before seizing a recording device, even if the person has been arrested and the device is seized incident to that arrest. Officers are still restricted from viewing, duplicating, or otherwise examining the contents of that material without a warrant. Even with a warrant, any photos or recordings belonging to an individual must never be deleted, destroyed, or altered. With any requirement under the Constitution, there are always exceptions to it. And so there are a couple of exceptions to the warrant requirement that are generally applicable in these kinds of situations. And these exceptions generally involve exigencies or an immediate need to protect public safety. So in one circumstance, you may have a recording that you believe contains evidence of a serious crime, such as a robbery or perhaps an officer-involved shooting. And it would not only be advantageous, but perhaps necessary to obtain and preserve that as evidence to be used in a prosecution. So if you decide that that's important, you're going to want to go down the road of seeking a warrant or the consent of the person to obtain that material. Another situation is where the video evidence may contain information that could prevent imminent death or serious bodily harm to someone. That's something where there may be an immediate exigency allowing you to suspend the warrant requirement for both seizing the video and perhaps watching the material contained in the video. So let's talk about what officers should do in these situations. If a justification exists to excuse the warrant requirement for the seizure of a recording or a recording device, you have to recognize that viewing the material still requires a warrant separate and apart from the seizure itself. unless it's immediately necessary to prevent significant harm. It may not even be necessary to consider having to obtain a warrant or any of the exceptions to a warrant requirement if you just talk to the person and they're cooperative. Consent is always your friend in these situations, and you might just ask them simply if they'll allow you to view the video, and if you decide it's important for evidentiary purposes, ask them if they'd provide a copy, perhaps even emailing a copy of their recording to an official email address. So always better to seek the path of least resistance, but if that's not possible, then a warrant's going to be your only option. If the person refuses to consent, either to allowing officers to view video material or to provide a copy, and there's otherwise no basis to legally obtain it via a warrant or an exception to the warrant requirement, then officers should not attempt to pressure, threaten, or otherwise force the person to surrender the video. So just to recap a little bit, warrantless searches and seizures are presumptively unlawful. So without a warrant, seizure of recording devices or media has to be based on exigent circumstances, such as the protection of evidence of a serious crime or the protection of someone from imminent threat or imminent threat of death or serious harm. So some key points to remember. Individuals have a First Amendment right to record the police and to disseminate that information. There are some limitations, however, on this right, such as time, place, and manner restrictions that seek to balance those rights against the government's needs to get the job done. Individuals cannot be cited, arrested, or the like for simply the act of recording in and of itself. In most cases, a warrant should be obtained before seizing a recording device unless an exception to the warrant requirement is applicable or the individual consents to providing or sharing the recording with you.